Paul Doyle, the individual at the heart of one of the most explosive and unsettling incidents in recent British memory, was due to appear before Liverpool Magistrates' Court today. In a development that has stunned legal observers and the public alike, that hearing has now been abruptly taken out of the local judiciary's hands, seized, without explanation, by none other than the Supreme Court of the United Kingdom. Yes, that is correct, the Supreme Court, the highest judicial authority in the land, a body typically reserved for constitutional disputes and landmark legal precedents, has intervened in a case involving a single man, a vehicle, and an appalling act of violence committed during what should have been a day of celebration in the heart of Liverpool. And the most astonishing twist? The President of the Supreme Court, Lord Robert John Reid, has refused to issue any comment. Not a word. No official statement, no press release, only silence. This is the same man charged with safeguarding public confidence in the British justice system, paid by the taxpayer to serve justice without fear or favour. And now, as a case that has shaken the nation is quietly redirected into the highest court in the land, he offers not a single justification. Let us take a step back. Monday, the 26th of May 2025. Tens of thousands of jubilant supporters had gathered in Liverpool city centre to celebrate their footballing heroes. The streets were awash with red, with flags waving high, cheers ringing out, and families united across generations for what was meant to be a day of joy. Then, disaster struck. A dark Ford Galaxy ploughed into the crowd. Panic ensued. Screams filled the air. Blood stained the pavement. 79 people were injured. The youngest victim was just 9 years old. The eldest, 78. A day that symbolized unity and pride was transformed into a living nightmare. At the center of the carnage, Paul Desmond Sanders Doyle, a 53-year-old man from West Derby, Liverpool. He now faces 7 serious charges, all of a violent nature. These include 2 counts of unlawful and malicious wounding with intent to cause grievous bodily harm, 2 counts of causing grievous bodily harm with intent, 2 counts of attempted grievous bodily harm, and 1 count of dangerous driving. All charges fall under Section 18 of the Offences Against the Person Act 1861, a statute that, while over 160 years old, remains a cornerstone of serious criminal law in Britain. This is not a technicality. This is a grave, high-level criminal case, one with potentially life-altering consequences. The Crown Prosecution Service, alongside Merseyside Police, have made it clear this is an extensive and ongoing investigation. Thousands of hours of CCTV footage are being analyzed. Witness testimonies are being collected. Mobile phone videos, dashcam recordings, and police body camera evidence are all under scrutiny. Yet, just as Doyle was set to appear before a magistrate in Liverpool, the entire legal process was derailed. The case has been escalated, suddenly, and without precedent, to the Supreme Court. Legal scholars and former judges alike, speaking off the record, have described the move as highly irregular, unusual, and deeply political. And here's what makes matters even more concerning: there has been no public explanation. No legal rationale offered. When approached, Lord Reid, the most senior judge in Britain, refused to offer even a token acknowledgement of the public's right to transparency. No comment. No statement. Nothing but an ominous and calculated silence. This is no ordinary case. This is a case involving mass public harm, a potential act of terrorism, or at the very least, a violent assault on innocent civilians during a national celebration. It touches on fundamental questions of public safety, judicial integrity, and institutional accountability. And yet, our highest court appears to be operating in the shadows, far removed from public scrutiny. Why the silence? Is national security at play? Is there government interference? Or is this an attempt to obscure the truth about who Paul Doyle is, who he may be connected to, and what truly motivated his actions? Earlier this week, public outrage erupted on social media as people questioned why certain details of the case, Doyle's identity, age, and background, were released with unusual speed by the police. Some praised this openness, others asked why similar transparency was lacking in other cases. Now, just as the people of Liverpool and the wider nation prepared for a court appearance that might offer answers, the gavel has been snatched from the local courtroom and placed in the secretive confines of the Supreme Court in London. Let us not dress this up. Something is deeply amiss. The air reeks of a cover-up. What is the motive? Could it be control? Are those in power afraid of what this trial might reveal? Is there more to Doyle's actions than a reckless outburst? Could it have been deliberate? Political? Are we once again witnessing a version of justice tailored for the powerful, where trials are tucked away in private chambers, while victims, 79 of them, are left to suffer in silence? And what of the people of Liverpool? Do they not deserve to witness this trial in their own city? To face the accused? To hear, in full, the grim truth of what unfolded that day? Instead, that right has been stripped away, not by the accused, but by the very institutions tasked with protecting justice and transparency. Let us be frank, this is not justice. This is obfuscation. And while Lord Reed may believe that silence in the face of controversy is dignified, the public sees it for what it is, cowardice. Paul Doyle may have been the man behind the wheel on that tragic day in Liverpool, but it is now the judicial and political elite who are firmly in the driver's seat, steering this nation toward what many are calling a constitutional reckoning. The British public deserves clarity. The victims demand justice. And unless someone speaks out soon, the fragile trust between the people and the justice system may never be restored. The question on everyone's lips is simple but devastating: what is being concealed, and who is being protected? Because if justice is to retain its meaning in modern Britain, it cannot be administered behind closed doors and in silence. Elsewhere across the nation, shock still lingers. A national celebration, intended to unite a city, has instead been stained by bloodshed. 79 people were injured, 7 of whom remain in hospital, including a child of just 9. And at the center of this public trauma, one name, Paul Doyle. Yet while the media, Merseyside police, and the Crown Prosecution Service scramble to maintain a consistent narrative, something feels off. And Prince William is not having it. Behind the polished press briefings and carefully orchestrated statements lies a case already beginning to buckle under the weight of its contradictions. Make no mistake, no one is attempting to downplay the horrific events of Water Street. The trauma was real, the consequences devastating. Families shattered in moments, lives irreparably changed. Doyle now faces a string of serious charges: dangerous driving, grievous bodily harm with intent, multiple counts of attempted wounding. However, in an extraordinary move, the Duke of Cornwall has broken royal silence, demanding what the public arguably needs now more than ever: verifiable truth. Not optics. Not theatrics. But evidence. Royal aides, speaking on condition of anonymity, have confirmed what many have long suspected: the future king is privately seething, not only at the horror inflicted that day but at the speed with which guilt has seemingly been assigned in the public eye before the full facts have come to light. "Show me the truth, not a scapegoat," those were reportedly the prince's words when briefed on the case. A sharp rebuke of a justice process increasingly seen as prioritizing image over substance. Let us not forget, this investigation remains in its early stages. The same authorities who have filed charges against Paul Doyle have also admitted they are still combing through hours of CCTV footage, still reviewing witness statements, and still appealing to the public for further video evidence. And yet, a full battery of charges has already been laid down. That is not justice. That is a public relations exercise dressed in legal garb. And who better to expose this contradiction than Prince William, a man who has spent his adult life navigating the corridors of an institution increasingly accused of silence, complicity, and decay. Not this time. Not on his watch. According to palace insiders, the prince was deeply troubled by how issues of ethnicity and background were exploited online, yet left unaddressed by official channels. When suspects conform to certain profiles, police and press are quick to reveal personal details. But when the profile doesn't align with preconceived narratives, there is an abrupt retreat into vagueness. While Merseyside police urged the public not to speculate, they simultaneously released just enough information to encourage precisely that, on their own terms. Now, with the prince's intervention, a direct challenge has been issued, and it is reverberating across Britain's political and legal establishment. Why this man? Why this case? And why such haste? These are not just questions from Kensington Palace. They are being echoed by thousands of ordinary citizens, increasingly skeptical of the motives behind the legal and media handling of this incident. To be clear, if Paul Doyle is guilty, then justice demands he be held fully accountable under the law. But justice also demands rigor, fairness, and due process, not a trial conducted in tabloids or a court of public opinion. The victory parade in Liverpool may have ended. The streets may have been cleared. But the rot beneath the surface remains. This is no longer merely about one man and one vehicle. It is about a deeper malaise within our institutions, how quickly process can be sacrificed in favor of appearance. And now, with the heir to the throne watching closely, the pressure to deliver genuine transparency is mounting. No more secrecy. No more calculated silences. The message from Kensington is unequivocal: Prince William wants the full truth. Because if justice is truly to remain blind, it must be guided by evidence, not politics, not public outrage, and certainly not by cover-ups. The people deserve the truth. The victims deserve justice. And Paul Doyle deserves a trial grounded in facts, not public performance. If the British legal system cannot offer that, then perhaps it is not merely Paul Doyle on trial, but the entire system itself. Supreme Court sparks national uproar over halal ban debate. In a separate yet equally incendiary development, the UK Supreme Court has now assumed jurisdiction over an escalating legal battle, one that pits religious liberty against the state's professed commitment to animal welfare. And at the heart of the controversy stands a familiar figure, Lord Robert Reid, President of the Supreme Court, who once again finds himself in the eye of a political and cultural storm. Yes, the highest court in the land is now weighing in on what many are calling the defining cultural conflict of the decade, one that has fractured Parliament, stirred division across communities, and thrown the entire nation into moral confusion. The issue? Whether halal slaughter, a centuries-old religious practice, should be outlawed on British soil. Animal rights activists, empowered by over 100,000 petition signatures and rising public outrage, have forced Parliament to reconsider its long-standing exemptions. Yet it is the Supreme Court's surprise decision to intervene that has sent shockwaves across the country. Lord Reid's reported position is stark: in a civilized society, animal welfare must come before religious exemption. That declaration, cold in tone and sweeping in implication, has ignited alarm across faith groups nationwide. The signal is clear: the Supreme Court appears poised to prioritize animal rights over centuries of protected religious practice. And to many, that sets a chilling precedent, one that risks recasting Britain's legal identity as both Christian majority and selectively tolerant. What prompted this judicial earthquake? Let us rewind.